Good morning and welcome. We have oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is August 19th, 2024. We have one case today on a petition to vacate James Lehet versus Roofers Advantage Program. Our file number WC 24-6549 with a date of injury of August 16th, 2001. I'd advise counsel that today's argument is being live streamed and recorded, and we would ask that you speak loudly and clearly during your respective arguments. We have a three-judge panel this morning hearing the petition to vacate. With me today on my left is Judge Sundquist. To my right is Judge Carlson, and again, I'm Judge Christensen. To review the rules today for oral argument, counsel each have 15 minutes to present their oral argument. The yellow light will go on at 2 minutes, and it will be up to each attorney to keep track of their time, and if you want to reserve time for rebuttal argument, to keep track of that. Please be aware that questions from the panel can be expected. I'm going to give each counsel 3 minutes of uninterrupted time before we begin to ask questions, and I will advise you at that 3-minute mark and tell you that questions can be expected. I think we have experienced counsel appearing before us today, and would just ask that after stepping up to the podium, that you please identify yourself and the party that you represent. And with that, Ms. Bulmer, you can begin.
Thank you, Your Honor. May it please the court. My name is Stephanie Balmer. I represent the injured worker petitioner, Jim Lehet. As the court is aware, we filed this petition to vacate a 2003 stipulation for settlement. The basis is Mr. Lahat's unanticipated and substantial change in medical condition. We also maintain that that change could not have been anticipated. Mr. Lehet is currently 55 years old. He was 34 years old at the time he entered into the 2003 settlement. I'm not going to go into his medical history. What I would like to address are some what I consider high points to our argument. First is this change in diagnosis with respect to the FODNess factors. I believe that this is actually the stickiest point to our petition because he has had so many different diagnoses, all of which are either based in or related to his lower back. And so I did address in my brief some of those post-stipulation diagnoses. I wanted to add a couple that I found. Lumbar pseudoarthrosis at the L5S1, and that's at employees 355 Bates, as well as lumbar pseudoarthrosis at the L45. He's also been diagnosed with chronic pain. Now, the reason these post-stipulation diagnoses are relevant is because at the time of the 2003 stipulation, his diagnosis was simply an L5S1 annular tear and disc degeneration in association with an isthmic spondylolysis with mild spondylolisthesis. And that was from Dr. Dennis at employees Bates number 337. Dr. Dennis was also recommending the initial lumbar fusion, which he said would allow Mr. Lehet to return to light duty at 6 weeks post-op. So that was the surgery that was prescribed at the time of the July 2003 stipulation. Dr. Dennis also noted that Mr. Lahat's chance of a good to excellent outcome is around the order of 85%. So that was the understanding that Mr. Lehet had going into this 2003 stipulation. Dr. Quinnemoen, Mr. Lahat's long-term occupational medicine specialist, agreed not only with the diagnosis, but with the fusion recommendation. And that's at employees Bates number 652. The surgery summaries, again, I cover both in my brief as well as in the medical records, but I'd like to point out that the 2020 surgery, which was Mr. Lahat's second surgery, was not for a new or different condition. It was to remove the irritating screws from the 2006 Fusion. We are not claiming that Mr. Lehet became disabled in 2020. We are claiming that he became disabled in 2022. And that was after the April 2021 surgery at a new level.
And we are at 3 minutes, so I would ask either Judge Sundquist or Judge Carlson whether they have any questions right now.
Yeah, Ms. Bulmer, to me, the stickiest issue here is the causation issue under the fondness factors. And I want you to tell us why you think that the 2019 injury did not sever the causal connection between the 2001 injury and the employee's current condition.
Yes, Your Honor. The 2019, the May 2019 incident, for lack of better terminology, came after the following. Mr. Lehet had seen Dr. Pinto in February 2018, so that was approximately 15 months before the May 2019 incident, reporting that over the last couple of years, his symptoms have gotten progressively worse. He was having right-sided low back pain. He felt increased pain lying down, difficult time sleeping at night, number of findings on examination. And in that February 2018 chart note, Dr. Pinto recommended removal of his hardware and exploration of the Fusion. In March of 2018, the next month, Mr. Lehet at Bates number 388 called Twin City Spine. No relief with injection. Within an hour, he had terrible throbbing in his back. If he is to have surgery, again, the removal of the hardware from the 2006 surgery, it needs to be later in the summer, 14 months before May 2019. In April 2019, the month before May 2019, Mr. Lehet again called Twin City Spine, that's at our Bates number 390. He would like to have his instrumentation removed. Additionally, Your Honor, not only do we have these actual chart notes reflecting the ongoing lower back complaints and requests to have the surgery that followed May 2019 done before May 2019 had ever happened, we had several additional complaints and diagnostics. He had an October 2017 MRI that was ordered because of the ongoing symptoms. Again, I have already talked about several of the dates of service that he had with Twin Cities Spine. There's no reference in Mr. Lahat's medical records to May 2019 because it wasn't an injury to him. He didn't pursue a claim because he didn't think it was related. The employer insurer wouldn't have known about what happened in May 2019 had we not filed this petition. That was how minute of an issue it was. There's been no proof of a change in symptoms. The procedures that he had after May 2019 had already been recommended before the incident. And Dr. Dunn, who is the only opinion on which this superseding intervening cause is based, has not issued a very persuasive report. I would like to note that the employer did not reference Dr. Dunn's report once in their responsive brief. They simply attached it as an exhibit.
Ms. Palmer, thank you for laying out those medical notes from Dr. Pinto. You know, certainly that is something we reviewed as well. But in addition, I want to discuss your client's own deposition testimony. His most recent deposition, when asked about what happened in 2019, he recited a specific incident. He talked about it being slippery, how heavy it was, who his coworker was, that he reported it. And he also went on to say that he had a sharp increase of pain. And these are my words. I realize I'm not quoting directly, but he had an increase of pain that lasted for a couple of years. So certainly in the medical records, he was having pain before this, but no doubt it was an event. Would you agree with that?
I agree that the incident occurred, but I also believe that Mr. Lehet described the symptoms as being similar after as to before.
Well, let me ask you this. Do you feel that the 2019 injury needs to be part of this litigation for a full and fair adjudication of all of the claims of all of the parties?
Thank you, Your Honor. That unfortunately is one of the limitations of this particular procedural process. First, we have some of these difficulties in analyzing Mr. Lahat's deposition testimony versus his declaration versus what is in the chart notes. And these, I believe, are fact-finding issues that deserve full and fair analysis. And so I very much appreciate the court reviewing that. The problem with the employer insurer's suggestion that this petition is premature is that Mr. Lehet has not pursued a workers' compensation claim for the 2019 incident because he doesn't believe it's related. And in fact, there was no medical opinion suggesting as much until he filed this petition. And so the Kinnunen case, which the employer insurer had referenced, has a very different set of facts. In that case, the injured worker had filed a claim against a Minnesota employer, and there was litigation pending to decide who was responsible for what. If that were the case in the instant matter, Your Honor, I absolutely would agree that this proceeding would be premature because a thorough fact-finding hearing wherein a compensation judge reviews all the medical records, is able to consider the employee's credibility in reviewing deposition testimony and the like. I do think that is the best way to determine medical causation, especially when a superseding intervening injury has been alleged.
So, Ms. Balmer, are you suggesting that the best option would be to have this case referred to the Office of Administrative Hearings for
Yes.
findings and order? I have a question about that. You have plenty of medical records and evidence to support a claim petition against the new injury. Why wasn't that filed?
Against the 2019?
Yes.
I disagree that we have enough evidence to pursue a claim against them. The only doctor who has said that it was related or that Mr. Lehet has been injured because of the 2019 injury is Dr. Dunn. And Dr. Dunn's report has a lot of problems. It's, if I might, we absolutely disagree with Dr. Dunn's opinions in that regard. She had a number of facts correct, but for example, Mr. Lehet had stopped golfing 8 years before May 2019. He stopped riding his motorcycle 4 years before May of 2019. But her analysis of the medical evidence in the years prior is unclear. She also is unclear about whether it was a repetitive trauma injury or an acute injury. Finally, I would be very curious to see how the employer insurer in this proceeding would respond if if they were on the risk as of May 2019. So we have Mr. Lehet, who'd sustained an admitted injury in 2001, had been referred for the surgery that took place in 2006, and then the removal and revision taking place after this alleged May 2019 date of injury. I think any employer insurer would deny responsibility for that claim and have a good reason for doing so.
Do you think that Dr. Dunn's report lacks foundation?
Yes.
In what way?
First of all, she's making a repetitive trauma diagnosis. She lacks information about the nature and extent of Mr. Lahat's work activities. Additionally, it's unclear whether she actually took into account the chart notes in the years prior to May 2019, since her opinions seem to contradict those. She also only met with Mr. Lehet once, well after all of these surgeries.
Thank you.
Maybe you can help me out too, because I'm looking at Mr. Lahat's deposition transcript from February of 2024. It's on page 63. And when regarding the May 2019 event, he was asked, that's okay. Did you ever file an injury report? The answer is yes. Question, did you ever pursue a workers' compensation claim? Answer, no. Question, why not? The doctor said it wasn't work related, Dr. Pinto. Is there anything in the records that have been submitted, first of all, that show that an injury report was filed in May of 2019 regarding that incident anywhere?
I don't have any such incident reports because, to be terribly frank, when I took over the file, there was no pursuit of that claim because Mr. Lehet was very clear that it was not part of his ongoing problems and it was not part of his disability. We did not ask Dr. Pinto about it. Dr. Pinto is very expensive, and again, when an injured worker is representing contents of a conversation with a doctor, I take those to be accurate, and that was what I would have expected Dr. Pinto to say.
And not to put words in your mouth, but
Sure.
just based on that, it would have been a conversation between Mr. Lehet and Dr. Pinto, I assume, that he was referring to in his.
That's my
deposition.
understanding. It certainly wasn't one in which we as his attorneys were present.
Ms. Balmer, in addition to the causation issues that we're talking about, something that I struggle with is whether this is really something that was not anticipated or could be expected. And in fact, in your client's depositions in 2006 and 2024, when asked, why didn't you have surgery when it was recommended? And again, these are my words, he said, I've heard the horror stories, I was afraid of the side effects. So he certainly had some understanding of the path that he was on. So how could this be unanticipated where he's at now?
I don't think anybody thought that things would go as wrong as they did. Certainly every surgical procedure has its risks, and the employer insurer referenced that in their responsive papers. But again, we have the surgeons estimating very high probabilities of success. And frankly, an injured worker who's basing his medical decision-making on barstool talk, I would certainly advise against relying upon that primarily for the employee's medical decision-making. Here, it's clear that the surgeons were repeatedly surprised by what had happened. We have physicians saying, well, I thought it was fused, but then it wasn't. And so we have the next level that is always possible. But again, the original fusion that was done, the idea was that it would be done and that he would return to work full time. And in fact, he did return to work full time for many, many years. And so I think with this particular facts, I agree that there are some questions about whether some of the surgical complications and diagnoses were anticipated, but what we ended up having was chronic pain with an upper right leg burning, which is very much a problem for him, which nobody seems to be able to explain, frankly, and disability. And Mr. Lehet has explained he wouldn't have entered into that settlement if he'd known he was going to have to retire at age 55.
Thank you.
Thank you.
Thank you.
Good morning. May it please the court. My name is Scott Ferris. I'm an attorney with Offet 40, Gray Munson and Hager, here on behalf of the Respondent Roofers Advantage Program and the Minnesota Insurance Guaranty Association. Right off the bat, I just want to address the documentation of this May 2019 injury. The employee, in fact, did report that he had an injury to the employer. The employer obviously did not file a first report of injury. We checked with the Department of Labor and were unable to obtain one. They did not have any record of it. Second, he also did report an injury to his doctors on June 26, 2019 at Essentia Health. He reported that he had an injury on May 15th or 16th, I believe he had said, when he was lifting this, multiple 100-pound object at work. So it has been documented that there was a re-injury. And even in Dr. Wengler's report, Dr. Wengler stated that there was a re-injury to his back in May of 2019. Regarding the foundation of Dr. Dunn's report, we provided her with over 1,800 pages of medical records, including the records that Ms. Balmer referenced just prior to this May 2019 injury. And Dr. Dunn did address those in her report. But I really want to focus on this May 2019 injury because it really is an issue in this case. The employee testified and in his declaration stated that he was lifting a very heavy object in a hunched over position and carried it approximately 20 to 25 feet, according to his declaration. He then testified that it was only a few feet. it's unclear which one it was. But regardless of that, this is a significant amount of weight that he's carrying in a hunched over position, and would cause an injury to likely anyone in doing that type of work. The case that's really on point with this, as Ms. Balmer referenced, is Noonan versus Brockway Glass. And in that case, it's almost identical, similar facts to what we have here today. The only difference being that in Noonan, the employee had already started the litigation process with the claim petition against the subsequent injury following the stipulation for settlement. In our case that we have here today, the employee still has time to pursue this 2019 injury. The statute of limitations has not run, as there's been no first report of injury filed. So he has until May of 2025 to file this claim. And it's premature to vacate an award pending the resolution of the outcome of that claim for the 2019 injury.
And let me interrupt you just for a second. 3 minutes have passed, so I'd ask either Judge Carlson or Judge Sundquist if they have any questions at this juncture.
Well, my question for you would be the same one that Judge Sundquist asked Ms. Balmer. Would you request that this court refer this to OAH for an evidentiary finding on maybe one of the issues being the nature and extent of an injury of 2019?
I think that is the proper course of action in this case, either that or having the employee file the claim petition.
Well, and let me ask you this, has your client paid for all of the medical since the stipulation for settlement, including the most recent surgeries?
Yes. So the 2003 settlement was for $78,000, which is about $133,000 in 2024 money. Medical benefits left open related to the original injury.
And has your client done anything to seek reimbursement from MEGA for any monies paid?
So at this
I'm sorry,
point,
your client is MEGA. Has your client done anything to seek reimbursement from the 2019 injury?
so we didn't learn about this injury until the petition to vacate was filed. We've had discussions with them. There is a contemplation of going back and doing that, but it's pending the outcome of the case and the petition to vacate that we're here about today before we move forward with the next steps in that.
And what's your understanding? Can MEGA, I know that you can't file a petition for contribution against MEGA, but can MEGA file petitions for contribution against other insurers?
That is my understanding, is that they would be able to, especially given the situation that we're in now, where we have newly discovered evidence that presents a new injury that we shouldn't have been responsible for.
Okay, thank you.
And my question is, so if I understand, up to the time of the stipulation for settlement or through the time of the surgery done in 2006, $78,000 had been paid in medical on behalf of Mr. Lehet?
No, the stipulation for settlement in 2003 was full, final, complete medical benefits open, and he received $78,000 for that settlement.
Do you know how much in medical benefits he had received up through the point of the stipulation for settlement?
I do not have that on hand at this moment, but I can provide it.
And that's okay. You don't need. And do you know how much the additional medical, because that's one of the fondness factors, have been paid on his behalf since the time of the settlement to the present time?
Yeah, and in regard to that, I don't have that specific number with me. Again, I can get it, but one of the fondness factors, there's the case Burke v. FM Asphalt, also states that less weight should be given to that particular fondness factor, the more costly and extensive medical treatment, when medical benefits are left open in the prior stipulation. And that's the case that we have here. So going to the fondness factors, the change in diagnosis, it's our position that even if there is a change in diagnosis, it's the result of this incident that occurred in May of 2019 and the 3 subsequent surgeries that he had in a period of a little less than 4 years after that 2019 injury. Prior to 2019, the last surgery was in 2006, and it was the one that was recommended back in 2002. He underwent fairly conservative treatment during that time, and according to most of the medical records, his pain was somewhat well managed. We're not denying that he wasn't in pain during that time, but it was something that has been under control. And in addition to the change in diagnosis, it's a known natural progression of having a lumbar fusion that adjacent levels are going to start deteriorating. And that's the subsequent fusion that he had in 2021 when he underwent the fusion at an adjacent level as well. The second FODNAS factor of the change in the ability to work, he continued to work full time up through 2020 when he underwent the hardware removal for the 2006 fusion surgery. So during that entire time, from the date of the stipulation in 2003 up until 2020 when he had his surgery, he was working full time that time. Now there was a short period where he's working part time when he was living in Florida for different circumstances, and then he had some light duty work after the 2006 surgery, but after his recovery from that, he returned to work full duty and was doing somewhat fairly well, it would appear, from the medical records and the lack of treatment during that time. FODNAS 3 is the additional change in permanency. There's no doubt that he has additional permanency now, but it's due to these 3 subsequent surgeries, specifically the additional fusion that he had following the 2019 injury. I touched on the FODNAS factor number 4 with the more costly and extensive medical treatment. The next issue to deal with or factor is the causal relationship of his current worsening condition and the original injury. Again, not to beat a dead horse, but this 2019 injury is all the treatment that he's been having for the last 5 years has been due to this 2019 injury. Yes, the hardware removal was recommended prior to that injury, but he never took action on it and didn't get it scheduled until after May of 2019. There's a lack of causal connection back to this 2001 injury, and the employee has not presented any evidence that it is in fact related to the 2001 injury.
And Mr. Ferris, I know you want to finish your factors, but since we're on this one, I want to get back to, I say Kinnunen, you call it Kinnunen. I think we know what we're talking about. The difference with Kinnunen, of course, is that there was litigation pending. And in this case, there's not. If there was a claim petition filed, it would be much easier. My question for you, again, is kind of walk me through where you would see this going procedurally. If Ms. Balmer says, I don't want to file a claim petition, I don't think I have the evidence for a new injury, and based on her client's, instinct that it's not new, what do you do then if she's not going to file a claim petition? Is there some claim that you can file so that there's litigation?
I think that there should be. I think we're going to have to. I'd go back and verify that we can go and make the claim for reimbursement for the treatment after the 2019 injury. But I think regardless, I don't think that the petition to vacate should be granted because it doesn't meet the FODNAS factors as well.
So are you saying that we should just deny the petition to vacate, and I'm sorry if I already asked you this, but I want to be clear, or do you think that the best course of action is to refer this to OAH for evidentiary findings?
I think the proper recourse would be to deny the petition to vacate and refer it back for an evidentiary hearing. It's premature to make an actual decision, I believe, on the petition to vacate.
Okay, thank you.
The last aspect of FODNAS, obviously, is the contemplation of the parties at the time of settlement. This was discussed by Ms. Balmer a little bit already, but at the time of the 2003 settlement, it was contemplated that there could be a worsening of his condition. It's indicated in the stipulation, and he signed off on acknowledging that he knows that his condition could worsen and potentially cause further disability down the road. He hasn't presented any evidence to the contrary to satisfy the 6th FODNAS factor. It's for these reasons that we ask that the petition to vacate be denied. Thank you.
And one of the other factors, at least as I understand at the time of the stipulation for settlement, was held open that he would have the fusion or surgery that was done later in 2006. Is that correct?
Correct.
And so at that point, I would assume it would be contemplated, or at least potentially, that you have a surgery, your situation is going to be worse, and then whatever would happen from that surgery, as Judge Carlson has asked previously. Is that fair understanding?
Yes, and he had acknowledged, through his deposition testimony even, that he had discussions with his doctors prior to the surgeries about the ramifications and possible side effects of going through with the surgery. So he was well aware of what could be coming down the road.
Any questions?
I'll reserve the balance of my time.
Thank you. We don't have any questions. Ms. Ballmer used her time up, so we're adjourned. Thank you.
Thank you.
Thank you.
It's very helpful.